Namaste and welcome to Daily News Simplified, the what, why and how of newspaper reading. Now we would be analyzing the Delhi edition of the Hindu newspaper of 16th of May 2019, and the news that would be covered today is given on the screen, and the timestamp for the same is given in the description and the comment section given below. And so now with this, let us start with the first article. Now we have taken this opinion-based editorial from page 9. Now what this article talks about is judicial activism versus judicial restraint. Now you need to understand that this editorial is much more relevant for those who are preparing for the political science optional examination, whereby this editorial talks about two schools of jurisprudence, first being the positivist school and second being the sociological school, whereby this editorial tries to explain the debate between judicial activism and judicial restraint by highlighting the concepts within the positivist school of thought in comparison to the concepts which have been given within the sociological school of thought. However, judicial activism is an important part of your GS examination syllabus, and therefore we're going to understand this editorial including the concepts of political science so as to understand the debate between judicial activism and judicial restraint from the perspective of your GS examination. Now this editorial should be seen from the perspective of GS paper 2 within the section Polity and within the subsection Structure, Organization and Functioning of the Executive and Judiciary, and more importantly from the subsection Separation of Power between the various organs, meaning the separation of power between the legislature, the executive and the judiciary. Now apart from this, various questions with regards to judicial activism has been asked in your UPSC mains examination, whereby the first question was asked in the mains examination of 2005, whereby it asked, is it possible to distinguish between judicial review and judicial activism? Does the recent behavior of the Indian judiciary partake more of judicial activism? Argue with suitable examples. This next question was asked in the mains examination of 2008, whereby it had asked, what is meant by judicial activism? Evaluate its roles in the context of the functioning of Indian polity. And the most recent question that was asked in the mains examination was in 2014, whereby the question had asked, starting from inventing the basic structure doctrine, the judiciary has played a proactive role in ensuring that India develops into a thriving democracy. In light of the statement, evaluate the role played by judicial activism in achieving the ideals of democracy. Now as you can see, several questions with regards to judicial activism has been asked in your GS mains examination. So now let us understand the views of the author with regards to the debate between judicial activism versus judicial restraint. Now the main crux of the author is that the Supreme Court within India is resorting further or moving further towards judicial activism rather than judicial restraint. However, before understanding the views of the author, let us first understand as to what is meant by judicial activism. Now in the simplest of terms, judicial activism means that judges enforce their own views with regards to constitutional requirements and policy preferences. Now these constitutional requirements which has been enforced by the judges based upon their own views would be contrary or against the view of the majority legislature. Similarly, the policy preferences which might be given by judges based upon their own views would be contrary or against the views of the executive. Therefore, when judges enforce their own views with regards to constitutional requirements or policy preferences upon the legislature or the executive, they move into the functions of the legislature or the executive. And therefore, this dilutes the separation of power between the three organs, that is the judiciary, the legislature, and the executive. So now hopefully you've understood as to what is meant by judicial activism, whereby under judicial activism, judges enforce their own views of constitutional requirement and policy preferences. And therefore these views of the judges are therefore against or contrary to the views of the legislature and the views of the executive. And through this form of judicial activism, it leads the judiciary into the functions of the legislature and the executive. And thereby it allows the judiciary to function above the legislature and the executive, and thereby dilutes the separation of power that exists between the three organs. Now, after understanding about judicial activism, it is also important to understand about the concept of judicial dynamism. Now, in simplest of terms, judicial dynamism is basically putting positive attributes to judicial activism, or trying to define judicial activism in a positive manner. Now, under judicial dynamism, the judiciary plays a proactive role in the protection of the rights of the citizens and the promotion of justice within the society. Now, one of the important aspects of judicial dynamism is that it implies an assertive role which is played by the judiciary so as to force the legislature and the executive to discharge their constitutional duties. Whereby what is currently seen within India is that the legislature and the executive are not properly functioning or discharging their constitutional duties. And it is within that regard that the judiciary has to intervene within the functions of the legislature and the executive so as to ensure and force the legislature and the executive to fulfill their constitutional duties. Now, there are several examples of judicial dynamism or judicial activism which has forced the legislature and the executive to fulfill their constitutional duties. Whereby the first main example of this would be the Vishaka Guidelines. Whereby what happened was that in 1997, the Supreme Court gave out the Vishaka Guidelines that intended for protection of women from sexual harassment within the workplace. And because of this Vishaka Guidelines that was given out by the Supreme Court, the Indian Parliament had to pass the Sexual Harassment at Workplace Act in 2013. And similarly, there are various other examples of the proactive judicial role for the protection of citizen rights, such as recently when the Supreme Court decriminalized Section 377, which was used by the police to harass the LGBT community. Similarly, as we have already understood, the Supreme Court gave out the Vishaka Guidelines for the protection of women from harassment at workplace, and it thereby forced the Indian Parliament to pass an act in 2013 with regards to the protection of women from harassment at workplace. So now hopefully up till here you've understood as to what is judicial activism and how it has been defined differently as judicial dynamism. Now let us understand the political thoughts which has been highlighted by the author with regards to the difference between judicial activism and judicial restraint. Now, according to the author, within the positivist school of thought, the center of gravity of the legal system is the law which has been made by the legislature. Now, what this means is that lawmaking is not the job of the judges, but of the legislature. However, in comparison, the author highlights the sociological school of thought. Now, according to the sociological school of thought, it shifts the center of gravity of the legal system to include laws that have been made by judges. Now, what the sociological school of thought does is that it increases the discretionary powers of the judges to make laws. Now, the best example of this would be the collegium system. Now, under Article 124 of the Constitution of India, it prescribes on how the Supreme Court judges are to be appointed, and nowhere in the Constitution of India or even by the fathers of the Indian Constitution have they said anything of a collegium system. Whereby it was in the second judge's case of 1993 and the third judge's case of 1998 that the judges of the Supreme Court created the collegium system of appointment of judges. Now, any form of lawmaking with regards to appointment of judges given under Article 124 is the responsibility of the legislature. And it is within that regard that the Indian Parliament passed the NJAC Act or the National Judicial Appointment Commission. However, what happened afterwards is the Supreme Court said that the NJAC is unconstitutional and continued with the collegium system, whereby this collegium system makes India one of the only democratic country in the world where the judges appoint other judges, whereby in every other democratic country, it is the executive or the legislature which appoint judges, which had been enshrined within the Indian Constitution also. Now, this is the main example given by the author within this editorial on how the Indian judiciary is following the sociological school, whereby they have widened their discretionary powers to make law. And the best example of this is the formation of the collegium system by the Supreme Court with regards to the appointment of judges. Now, it is within that regard that the sociological school of thought of jurisprudence mainly supports the argument for judicial activism, whereby it is the positivist school of thought according to the author which mainly supports judicial restraint. Now, the positivist school ensures that there is a separation of power between the three organs, that is the legislature, executive and the judiciary, and the judiciary should not be making interventions within the fields of the executive or the legislature. However, the sociological school of thought promotes the widening of discretionary powers of judges with regards to lawmaking. Now, it is within that regard that the author is saying that the Indian judiciary is currently following the path of the sociological school. So now hopefully up till here you've also understood the difference between the views of the positivist school and the sociological school. Now, the last aspect that this editorial talks about are the various problems that have arisen due to the Indian judiciary following the sociological school of thought. Now, the first problem, which has been highlighted by the author, is that by following the sociological school, it would give the judges a free handle to declare any law according to his own subjective notions. The second problem highlighted by the author that out of all the three organs of the government, which is the legislature, executive, and judiciary, it is only the judiciary that can define the limits of all the other organs. Now, because the judiciary is empowered to define the limits of its own power, then it becomes very relevant for the judiciary to self regulate. Now, the third and the final problem, which has been highlighted by the author, is that it leads to the substitution of the judgment of a competent administrator. Now, the author has highlighted an example within the editorial whereby he says that judges may not have the required knowledge with regards to taxation, environment, technology, and other various aspects. And therefore, when judges substitute a judgment that has been given out by an executive or a bureaucrat who are knowledgeable within the field of taxation or environment or technology, then what it does is that it substitutes the judgment of a competent administrator within the executive by an individual judge who may not have the required knowledge of that field. So now hopefully you've also understood the three problems which has been highlighted by the author with regards to the Indian judiciary following the sociological school of thought or Indian judiciary indulging within judicial activism. And hopefully with this you have understood the main focus of this editorial with regards to judicial activism versus judicial restraint. And so now with this, let us move on to the next article. Now we have taken this opinion-based editorial from the editorial page on page 8. Now the main focus of this editorial is quite small, whereby the author within this editorial has been saying that India has been proactive within its engagement in the Indian Ocean, but has also shown a defensive mindset with regards to its engagement within the Indian Ocean. Now what we'll do is first try to understand on how India has been proactive within the Indian Ocean, and then try to understand as to what the author means when it says that India has a defensive mindset when engaging within the Indian Ocean. Now, the first aspect highlighted by the author on how India has been proactive within its engagement within the Indian Ocean is the conducting of naval exercise with major Indian Ocean powers and also conducting naval exercises with countries located in the Indian Ocean. Now, the naval exercises that India conducts with major Indian Ocean powers include the Varuna naval exercise that India conducts with France, the Malabar naval exercise that India conducts jointly with the United States and Japan, the AUS Index naval exercise that is conducted between Australia and India. Now, apart from this, major naval exercises that India conducts with countries located in the Indian Ocean include Samudra Shakti that is conducted with Indonesia. And it is also to be understood that the first bilateral naval exercise, Samudra Shakti, was conducted between India and Indonesia in 2018. Similarly, India conducted the INVPN military naval exercise with Vietnam. Now, apart from this, India also engages in multilateral naval exercises such as Milan, whereby the Milan 2018 military exercises was conducted in the Andaman Sea and included participation from Australia, Thailand, Vietnam, and other navies of countries located within the Indian Ocean. Apart from this, what you should also know is that India also engages in naval exercises with Maldives, Mauritius, Sri Lanka, and other smaller countries that are located within the Indian Ocean. Now, the second proactive engagement that India undertakes is counter-piracy missions off the coast of Somalia. Apart from this, India also undertakes humanitarian and disaster relief operations within the Indian Ocean. Now, Indian Navy undertook Operation Sahayata in 2019 after Cyclone Idai had made a landfall on the eastern coast of Africa within the country of Mozambique. Similarly, Cyclone Meknu hit the Yemeni island of Socotra in the Gulf of Eden, and therefore the Indian Navy undertook Operation Nestar in 2018. Apart from this, the Indian Navy also undertook Operation Samudra Maitri within 2018 so as to assist Indonesia with regards to disaster management because of an earthquake and the subsequent tsunami that had hit Indonesia. Now, the third proactive engagement which the author has highlighted is that the Indian Navy has increased its focus on undersea surveillance and on anti-submarine warfare. Now, the fourth and the last proactive engagement which the author has highlighted is that India is seeking naval logistic access to the French bases located in the Reunion Island and in the country of Djibouti. Now, India and France has signed a logistics agreement within 2018. Now, under this logistics agreement, India would have access to French military facilities which are located within the Reunion Island or in the country of Djibouti. And what is currently being seen is that India is asking and seeking this naval access to French bases within the Indian Ocean. Now, these are the four main proactive engagement that the author has highlighted that India has undertaken within the Indian Ocean. Now, the main reason as to why India has undertaken such proactive engagement is something that you already understand, is that because of the increased presence of China within the Indian Ocean. Now, as you may already understand, that China already has a military base within Djibouti, and therefore Indian access to the French base in the country of Djibouti would allow India to oversee the Chinese base within the country of Djibouti. Similarly, one of the main reasons as to why the Indian Navy has increased its focus on undersea surveillance and anti-submarine warfare is because of the improvement in technology of the Chinese Navy in the movement of submarines under the ocean. So now hopefully up till here you understood the first part of this editorial on how India has improved its proactive engagement within the Indian Ocean. Now let us understand the second aspect of this editorial on why, according to the author, India also has a defensive mindset with regards to its engagement in the Indian Ocean. Now the first reason given by the author is that India has continued to maintain a silence of China's continuing aggression in the South China Sea. Now, it needs to be understood that India has proactively engaged with the ASEAN organization and various countries located in the South China Sea, whereby India has said that there should be free and open access to the South China Sea, and any dispute within the South China Sea should be resolved based on international law. Now, the second defensive mindset, which has been highlighted by the author, is that India continues to engage with the Chinese Navy. Now, the author has highlighted that Indian warships were recently sent in April of 2019 to a Chinese fleet review. And therefore, according to the author, this engagement with the Chinese Navy shows a defensive mindset. However, it also needs to be understood that China is a major Indian Ocean power. And apart from engaging with France, US, Japan, Australia, India also needs to engage with China also. The third point highlighted by the author is that India is continuously highlighting the economic concerns of Belt Road Initiative and not highlighting the military concerns of Belt Road Initiative. Now, there have been various reports of Chinese Navy presence within the Gwadar port within Pakistan, the Hambantota port within Sri Lanka, and according to the author, India is not highlighting the military concerns that it has with regards to the Belt Road Initiative of China within the Indian Ocean region. However, you need to understand that with Pakistan, India really can't do much with regards to the military concerns. However, with countries such as Sri Lanka and others who are located within the Indian Ocean region, India has made sure that any naval base that has been built by China, such as the Hambantota port in Sri Lanka, is not used for military purposes. And this India has ensured by bilateral engagement with that particular country, such as Sri Lanka, Myanmar, and others. Now, these are the three main examples which has been highlighted by the author, which showcases India's defensive mindset with regards to India's engagement in the Indian Ocean. Now, this editorial and the explanation given in this section should be seen from the perspective of GS Paper 2 within the section International Relations. Apart from this, the various naval exercises and the various humanitarian and disaster operations that India has undertaken should also be remembered from the perspective of your prelims examination. And so now with this, let us move on to the next article. Now we have taken this article from page 12. Now this article and the explanation given in this section should be understood from the perspective of your prelims examination within the section Current Events of International Importance. Now what has happened is that New Zealand gave out a Christchurch call to action. Now as you may remember, Christchurch was one of the sites in which an horrific terrorist attack happened in New Zealand. Now the main aim of this Christchurch call to action is to eliminate terrorist and violent extremist content online. Whereby several countries and companies have signed this Christchurch call to action to eliminate terrorist and violent extremist content online. Now it is within that context that India has said that it is also going to sign this Christchurch call to action. Now this is what is required for you to remember about the Christchurch call to action with regards to your upcoming prelims examination of 2019. Now apart from understanding the Christchurch call to action, there's several other global initiatives that you need to remember for your prelims examination. Now the first initiative that you need to remember is the Global Internet Forum to Counter Terrorism. Now in 2017, the company of Facebook, Microsoft, Twitter and YouTube formed the Global Internet Forum to Counter Terrorism. Now the main aim of this Global Internet Forum is to prevent terrorists from exploiting the platforms of Facebook, Microsoft, Twitter and of YouTube. Now, these four companies have formed this global internet forum so that their platforms are not used for terrorist and violent extremist purposes. The second initiative that you need to know is the Global Counterterrorism Forum. Now, this Global Counterterrorism Forum was launched in 2011 as an informal, apolitical, and a multilateral counterterrorism platform. Now, the main aim of the Global Counterterrorism Forum is the implementation of the UN Global Counterterrorism Strategy, whereby the United Nations is a close partner of the Global Counterterrorism Forum. And apart from this, India, China, Pakistan, United States, and several other countries are members of the Global Counterterrorism Forum. The third global initiative that you need to remember is the Tech Against Terrorism. Now, this Tech Against Terrorism was launched by the United Nations Counterterrorism Committee Executive Directorate. Now, this United Nations Counterterrorism Committee is basically related to the UN Global Counterterrorism Strategy. And this Tech Against Terrorism is being implemented by a company called QuantSpark. Now, the main aim of this Tech Against Terrorism is to help the global tech industry to protect itself from terrorist exploitation. Now, you also need to understand that the Global Internet Forum, which was formed by Facebook, Microsoft, Twitter, and YouTube, is also a partner of Tech Against Terrorism. The fourth initiative that you need to know is of the Aqaba process. Now, the country of Jordan has launched the Aqaba process to promote the de-radicalization of radical Islamic ideology. Apart from this, what you also need to understand that India is an active participant in the Aqaba process that has been launched by Jordan. Now, the fifth and the last initiative that you need to remember is Paris Call. Now, the UNESCO Internet Governance Forum held a meeting in Paris in 2018 and gave the Paris Call for Trust and Security in Cyberspace, whereby this Paris Call for Trust and Security in Cyberspace intends to develop common principles for securing cyberspace. Now, there are more than 190 participants in the Paris Call, whereby it includes both countries and several major tech companies such as Facebook, Google, and others. Apart from this, you also need to understand that India, China, United States are not participants in the Paris Call. Now, these are the main initiatives that you need to remember with regards to your prelims examination. And so now with this, let us move on to the next article. Now, we have taken this article from page 1. Now, what has happened is that the Election Commission has imposed a blanket ban on campaigning activities of political parties within several parliamentary constituencies in West Bengal. Now, it is within that regard that you need to understand the powers of the Election Commission has been provided under Article 324. Now, it is Part 15 of the Indian Constitution that deals with the topic of elections, whereby Article 324, Clause 1 states that the superintendence, direction, and the control of the preparation of electoral rolls for the conduct of all elections, that is to the parliament, to the legislature of every state, and that to the elections of the offices of president and vice president, shall be vested with the Election Commission. Now, what Article 324 provides is that it has vested the Election Commission with the superintendence, direction, and the control of elections. Therefore, it was in respect to the powers provided to the Election Commission under Article 324 that it imposed various bans on the campaigning activities of political parties in parliamentary constituencies in West Bengal. Now, with regards to this ban within West Bengal, the Election Commission has also referenced the verdict of the Supreme Court in the Election Commission vs. State of Haryana case of 1984, whereby the Supreme Court held in this case that it is the presumption of the Election Commission that would prevail over that of state government and even high courts with regards to law and order situations in those areas which are going to have elections, whereby the Supreme Court has said that it would be the opinion of the Election Commission that would prevail over that of the state government and even the High Court with regards to law and order situations in those areas which are going to have elections. Therefore, the action that has been undertaken by the Election Commission of India in West Bengal is therefore supported by the Election Commission of India vs. State of Haryana verdict of the Supreme Court. Now, there are several restrictions which has been imposed by the Election Commission in West Bengal, which includes that no person should hold, convene, attend, join, or address any election-related public meetings. And similarly, a ban has been imposed on the sale and distribution of liquor. And similarly, several other bans have been imposed by the Election Commission. But the specific bans that have been imposed by the Election Commission in West Bengal are not required to be remembered with regards to a UPSC examination. But hopefully you've understood about Article 324 and the election of India versus State of Haryana case of 1984. And so now with this, let us move on to the next article. Now we have taken this article from page 13. Now what this article highlights is that the Reserve Bank of India has released a vision document with regards to payment systems for 2019 till 2021. Whereby this payment systems vision of 2021, which has been released by the Reserve Bank of India, contains 36 specific action points and 12 specific outcomes. And the main aim which has been given in this vision document is that the Reserve Bank of India wants to achieve a highly digital and a low cash society. And what we're going to do with regards to this article is undertake questions for practice with regards to payment systems. Now there are 3 questions for your practice, and what you need to do is pause this video, solve all of these questions and wait for 5 seconds for the correct answer. Now the correct answer to question number 1 is D, 1, 2 and 3. Now the payment and regulatory system refers to the system which facilitates the transfer of money from a payer to a beneficiary. Therefore the payment and regulatory system includes both paper-based payments such as check and drafts, and also includes electronic payment systems such as real-time gross settlement or RTGS, National Electronics Fund Transfer or NEFT, Immediate Payment Services or IMPS. Similarly, it also includes UPI and several other forms of paper-based and electronic-based payment system. Now with regards to question number 2, the correct answer is C, both 1 and 2, whereby the Payment and Settlement Act of 2007 authorizes the Reserve Bank of India to constitute a committee from its own central board known as the Board for Regulation and Supervision of Payment Settlement System. And this Board for Regulation of Supervision of Payment and Settlement System would be the highest policy making body on payment systems within India. Now with regards to question number 3, the correct answer is A, whereby currency in circulation includes notes which are in circulation, the rupee coins, and including the small coins which are with the public and also with the banks. Now apart from this, basic information with regards to the payment and settlement system and with regards to the Payment and Settlement Act of 2007 is also provided in today's PDF. And you can refer to this PDF to understand the explanation given in this section with regards to payment and settlement system and with regards to Payment and Settlement Act of 2007. And so now with this, let us move on to the next section. Now there are 3 more questions for your practice, and as you already understand, pause this video, solve all of these questions and wait for 5 seconds for the correct answer. Now the correct answer to question number 4 is B, 1, 3 and 4, whereby the UNESCO Internet Governance Forum led the meeting to form the Paris Call. Similarly, the Aqaba process is being led by the country of Jordan, and the Tech Against Terrorism is being led by the United Nations Counter-Terrorism Committee Executive Directorate. Now the Global Internet Forum to Counter Terrorism is not being led by the Financial Action Task Force and is rather being led by 4 major companies, which are Facebook, YouTube, Microsoft and Google. Now with regards to question number 5, as we have already understood, the Christchurch Call to Action is related to eliminating terrorist and extremist content online. Now question number 6 has been asked in the prelims examination of 2017. And the correct answer to question number 6 is A, that judicial review implies the power of the judiciary to pronounce upon the constitutionality of laws and executive orders, whereby judicial review means that it is the power of the judiciary to say whether the laws or the executive orders which has been passed by the legislature or the executive are constitutional or not. And now with this we come to an end in the analysis of today's newspaper. Now we move on to the question for today.